5 seconds to go. Start. The crucial holding under section 32 is that a person is not under sentence of death, even if the sessions court has sentenced him to death subject to confirmation by the High Court. He is not under sentence of death even if the High Court imposes, by confirmation or fresh appellate infliction, death penalty, so long as an appeal to the Supreme Court is likely to be or has been moved or is pending. Even if this court has awarded capital sentence, it was held that section 30 does not cover him so long as has his petition for mercy to the governor and or to the president permitted by the constitution, has not been disposed of. Of course, once rejected by the governor and the president, and on further application, there is no stay of execution by the authorities, the person is under sentence of death. During that interregnum, he attracts the custodial segregation specified in section 32, subject to the ameliorative meaning assigned to the provision. To be under sentence of death means to be under a finally executable death sentence. Para. Even in Triveni Ben versus State of Gujarat, this court observed that keeping a prisoner in solitary confinement is contrary to the ruling in Sunil Batra and would amount to inflicting additional and separate punishment not authorized by law. It is completely unfortunate that despite enduring pronouncement on judicial side, the actual implementation of the provisions is far from reality. We take this occasion to urge to the jail authorities to comprehend and implement the actual intent of the verdict in Sunil Batra versus Delhi administration. Para. The benefit of commutation was, however, granted in Ajay Kumar Pal on the ground that the solitary confinement was against the principles laid down in Sunil Batra and also on the ground of delay. Having considered the entirety of the matter, in our view, the impact of solitary confinement were obviously evident in the instant case, as would be clear from the letter given by the medical professional on 6th November 2011 and the communication emanating from the jail on 8th November 2011. The incarceration in solitary confinement thus did show ill effects on the well-being of the appellant. In the backdrop of these features of the matter, in our view, the appellant is entitled to have the death sentence imposed upon him to be commuted to death sentence to life. Para. At this stage, we may refer to a recent decision by a 3-judge bench in Muhammad Manan alias Abdul Manan versus State of Bihar, where while accepting the review petition, the sentence of death was commuted to imprisonment for life. However, it was observed in paragraphs 87 and 88 as under :para. Even though life imprisonment means imprisonment for entire life, convicts are often granted reprieve and or remission of sentence after imprisonment of not less than 14 years. In this case, considering the heinous, revolting, abhorrent and despicable nature of the crime committed by the petitioner, we feel that the petitioner should undergo imprisonment for life, till his natural death and no remission of sentence be granted to him.